Hi, I'm Lawrence Gund, criminal defense attorney with the Kann California Defense Group. I'm going to talk today about a felon in possession of a firearm, which is covered under California Penal Code 29800. In order to be found guilty of this charge, it has to be shown either that you are a convicted felon, which can be applied to being found guilty of having a previous felony from any state, any government, or in any country. It also includes a list of certain misdemeanors, or if you are addicted to narcotics. The elements that have to be found for you to be a felon in possession of a firearm would be one, possession. Now, this can be actual possession or constructive possession. Actual possession would be that you have it in your hand, you have it in a holster on your belt, maybe in your pocket, tucked into your pants. Constructive possession would be that you have access to the gun. Say, for example, it's in a box that you keep in a shelf in your garage or in the closet of your bedroom. That would be considered actual possession. The charge is called felon in possession of a firearm, but as mentioned before, there are certain misdemeanors that can prohibit you from owning a gun for 10 years. Penal Code 29805 covers that list of misdemeanors, but some of them are battery, brandishing a firearm, assault with a deadly weapon, criminal threats, or domestic violence. It should also be noted that a misdemeanor domestic violence charge, even though under California law it only carries a 10-year prohibition from owning a firearm, there is a federal law which makes it a lifetime prohibition for owning a firearm, and that does supersede the California law. Some valid defenses to the charge of a felon in possession of a firearm are, one, of course, that simply you didn't do it. You didn't have a gun. Another one would be that you have no knowledge of the presence of the gun. Again, say, for example, you just moved into a house and there's that box in the garage and it's found that there's a gun in there, but you didn't put it there. It was there when you moved in the house. You had no knowledge of its presence. Well, then you couldn't be found guilty of being a felon in possession of a firearm. Another defense would be that you had no access or control over the gun. Say, again, that you've got a safe in your house, but you don't know the combination, you don't have a key to it, or any way to knowledge of how to get a key, then you would not be found to be in possession of a gun. So again, that charge wouldn't stick. Another defense would be if you had to use the weapon in self-defense. Say, for example, you legitimately feel that your life is in danger or that you're in danger of imminent and great bodily harm from somebody. Suddenly a gun becomes available to you and you have no other reasonable means to defend yourself, then you couldn't be found as a felon in possession of a firearm. Another defense would be if you had only momentary possession of the gun in order to sell it or dispose of it or have it destroyed. That also would be a valid defense. The final defense would be that you had justifiable possession of the gun. Say, for example, that someone was threatening you with a gun and you were afraid they were going to use it against you and you wrestle it away from them. Well, that would also be a valid defense to possession of a firearm by a felon. Now, this charge can carry up to 3 years of prison time and or a $10,000 fine. So if you or anyone you know is charged with being a felon in possession of a firearm, please call us at the Kann California Defense Group. We'd be very happy to talk with you about ways that we may be able to get the charge either reduced or dismissed.